Hello, my name is Andrew Needle, and I am a board certified civil trial lawyer in the state of Florida. I've been practicing for over 40 years, and I've handled just about every kind of personal injury case imaginable. And today we're going to talk about the very disfavored uh, area of slip and fall cases. Now, when I say disfavored, it's because insurance companies often view them as associated with fraud. The legislature in Florida has passed statutes to make it more difficult to recover in slip and fall cases. But the reality is that they are very real. The problem that underlies most slip and fall cases is that if the damages are not large enough, they cannot really be litigated in court because of the expenses associated with it. So we're going to talk in very general terms about slip and fall cases and ignore for the moment any concern about the economic feasibility of the case. So let's get started with what is a slip and fall case, sometimes called a trip and fall case. It usually involves some sort of defect in a floor. It could be slippery tile. It could be a foreign substance on the floor. It could be a carpet that is coming up or it is torn that captures the heel of your shoe, especially women's shoes, which may have high heels. It also may involve cases where you're going up and down stairs and the stairs may not be in compliance. But we're going to focus today on the run-of-the-mill garden variety slip and fall case, which typically would occur in a supermarket where it seems like most of them do. It also could occur, obviously, in a shopping mall, but supermarkets tend to be the location because there are a lot of opportunities for foreign substances to be deposited on the floor under various circumstances. So back about, maybe 10 years ago, the Florida legislature, after being lobbied by insurance companies, which happens every year, passed a statute called Florida Statute Section 768.0755, which deals with premises liability for transitory foreign substances in a business establishment. Now, in plain English, that means water or oil or some other substance that's on the floor at the place of business. In this case, we're talking about supermarkets. And the statute says that if a person slips and falls on a transitory foreign substance in a business establishment, the injured person must prove that the business establishment had actual or constructive knowledge of the dangerous condition and should have taken action to remedy it. Constructive knowledge may be proven by circumstantial evidence showing that the dangerous condition existed for such a length of time that, in the exercise of ordinary care, the business establishment should have known of the condition, or the condition occurred with regularity and was therefore foreseeable. This section does not affect any common law duty of care owed by a person or entity in possession or control of the business premises. Now, what that last section refers to is the duty that's been imposed under common law, meaning going all the way back to England, that a premises owner owes a duty of reasonable care to its invitees, meaning people who are on the premises for business purposes, or have been invited onto the premises by the landowner themselves. That's a duty to maintain the premises in a reasonably safe condition and also to warn of conditions which may be hazardous and the particular person who's come onto the premises may not be aware of. Now, the first couple of sections deal with something called constructive notice. Now, constructive notice or circumstantial evidence, it means that the business operator should have known of the presence of the foreign substance on the ground. This is very different than circumstances where you're able to prove that some employee dropped water on the ground or dropped oil on the ground or dropped some sort of container that came open and deposited liquid on the ground. If you can prove that the individual employee dropped it, okay, then and didn't clean it up, then it's a different category of negligence. That's more or less direct negligence on the part of the employee, much easier to prove if you've got the evidence. Now, how might you have that evidence? Well, it's very common these days for supermarkets to have surveillance cameras all over the store to prevent shoplifting. And these surveillance cameras record what's going on, and they will usually show what has happened. Now, the problem is that they don't always keep the images for long periods of time. Sometimes they record over them automatically, and they'll deny that they have them present. And a lot of times they'll just refuse to provide them, claiming that they have a privilege to maintain them because they're in anticipation of litigation. The courts vary on how they treat this. Sometimes judges will order the production of those surveillance videos if they exist. Other times they will not. But if you're lucky, you'll have good surveillance video of what was going on there. And these surveillance videos also have timestamps. So if you can see how long a particular substance has been on the ground, then you're pretty much on your way to having a successful personal injury case, slip and fall case, based on how long the substance was on the ground. So that's item number one. How long has it been there? The cases that have come down recently really vary, and they're all over the place. There are ways that you can point to the substance on the ground and say, hey, I know, okay, that it was there for a sufficient period of time for the business owner to be aware based on XYZ. What was the condition of the liquid? Okay. And some of the things that the courts have looked at might be, get to that in a second here. They might look to several factors, including evidence of footprints in the substance, prior track marks, like from a shopping cart, changes in the consistency, such as a liquid or other substance drying out, where you can see the outline of where it was originally and how it shrunk because it's dried. These are items that create questions about how long it's been there, and that will help you get to the jury. If you can't prove those things, then the court is going to direct a verdict in favor of the defendant, meaning the supermarket, and you'll never get a chance to get it to the jury. So being able to prove how long the substance was on the ground is essential to the proof of the case. And being able to demonstrate how long it was is really important. So what do? Well, we talked about surveillance cameras a moment ago. They're great if you can get it, but there are other things that you have to be aware of too. And I'll call these just kind of the rules of the road if you're involved in a slip and fall case. First, okay, if you fall, everyone's embarrassed when they fall. Don't just pop up and say, oh, I'm okay. I'm okay. Stay down. If you're hurt, stay down. Okay. Don't say to any of the employees or anybody else that may be present with you, oh, I'm sorry, I didn't see that. Nobody walks around looking at their shoes. You always look forward, especially in supermarkets. You're staring at the shelves. It's intended that you stare at the shelves because you're looking for products, and they want you to look at products and buy their products. And they're put at eye level. They don't put them on the floor. So you're not looking down when you're walking. And so you're not expected to be able to see things that are on the ground. So don't say, I didn't see it. Let them prove that you didn't see it or that it wasn't there. Okay. Don't hesitate to accept help. If they say, let us call fire rescue. If you're hurt, let them call fire rescue or an ambulance or other emergency services. If you're not going to allow them to call services, then it's going to be more difficult for you to prove that you actually were injured in the slip and fall. Which brings us to the next point, which is make sure that you get to your physician or to an emergency room or urgent care center as soon as possible after the slip and fall, so that you can document what happened and that your complaints were immediate and didn't just happen a week or two later, which could be related to something else, such as a pre-existing condition or some other fall that they may claim. There are lots of ways to defend these cases, and they're very difficult to prove. And so what you need to do is put together your case when you fall. Now, everybody carries a cell phone. Cell phones all have cameras these days. It's important that if you fall, take a picture. Take a picture of what you fell on. Once you're on the floor, you are able to take a picture of those things. If you're with somebody else, let them take a picture of it. But don't forget to preserve that evidence. Otherwise, there'll never be a way, if you don't have a surveillance video from the store itself, to show exactly what it is you fell on. Now, in addition to taking that picture on the ground, okay, you may want to take a picture of other people who are around you, such as witnesses that you may identify, or store employees who may have knowledge of the condition, because they may be able to testify that, oh, this happens all the time. For instance, if you're in the produce departments often have sprayers. These sprayers go off periodically because they want to keep the vegetables moist. They want to keep them wet. And those sprayers very often will overspray and get onto the floor. And that may be the substance that you fell on. So if you have a picture of these sprayers in action, there you go. You've gone ahead and you've preserved that evidence. So documenting what happened is very, very important. And what you want to also do is when you get home, you want to make notes about what happened. You would be surprised how quickly you forget the specific events. So while things are fresh in your mind, make a list of everything that happened, okay, along with the time if you're able to. And also keep a diary of what happened to you afterwards, the pain that you've experienced, the difficulty that you've had. All of these things contribute to being able to prove your case. Because remember, in a personal injury case, the plaintiff, meaning you, always has the burden of proof, meaning you have to come forward and demonstrate that there is a case that meets all the essential legal elements in order to get to a jury. Without that, you're not going to win your case. So I hope this has been helpful. And if you have any questions, please feel free to Google me, look me up, send me an email, and I'll be happy to try and respond. Thanks and have a great day.